Good evening, friends. Welcome you all to StudyIQ IAS English. This is Vishal, Faculty of Law Optional and Indian Polity at StudyIQ. In today's video, we're going to discuss an important judgment related to constitutional law by the name of DC Wadhwa versus State of Bihar. You must have heard about ordinances. You must have heard that the president as well as the governor of a state has been given power to promulgate ordinance in case the government need a law. In case the government need a law and either the parliament or legislative assembly is not in session. So to deal with that particular scenario, an emergency power has been given to the executive. That means the president as well as the governor. So in case the government want to bring in a law, suppose they want to deal with a particular subject that is emergent, or they want to deal with a subject that has become, or there is an imminent need to enact a legislation, but the parliament is not in session or the state legislature is not in session. Now we all of us understand that legislatures do not remain in session for 365 days an year. They remain in session for limited period, for example 100 days, 105 and 110 days in a year. Now to deal with this particular situation, executive has been given extraordinary power to make laws through the medium of ordinances. But this is a measure that has to be resorted to only in emergent situation, and that too with limited amount of authority. But in Bihar, during the time of 1960s until 1980s, a peculiar pattern was noticed. In Bihar, the state government was promulgating ordinances repeatedly. See, ordinance is an exceptional measure that has to be resorted to in time of emergency, and the life of ordinance is also limited. That means, suppose the governor of the state or the president promulgates an ordinance. Now, as soon as the legislature sits in session, that means as soon as the session of the legislature initiates, within 6 weeks of reassembly of the legislature, the ordinance has to be passed. So that means the government can take care of emergency situation by passing the ordinance, but as soon as the session of legislature starts, the ordinance has to be passed by the or approved by the legislature. Now, in Bihar, there was a practice in which the state government was promulgating ordinances. Sorry, my bad. The state government was promulgating ordinances one after another. They were not even trying to get the ordinance passed through the ordinary legislative process. So they used to promulgate an ordinance. The ordinance used to lapse, then they used to again promulgate the same ordinance with same content. And this was happening repeatedly in Bihar, to an extent that within a span of 14 years, the Bihar government promulgated approximately 250 ordinances, and they did not even try to pass those ordinances through legislature. Now a writ petition was filed in the Supreme Court, and this practice was challenged for being unconstitutional, because constitution has given you an exceptional measure to deal with exceptional situation. That does not mean you use that instrument to bypass the normal legislative framework. So in today's video, we're going to see that what was the judgment of the Supreme Court in the case of DC Wadhwa versus State of Bihar, and how this judgment proved instrumental in curbing this unconstitutional practice of promulgating the ordinances again and again without making any efforts to pass them through legislatures. See, in Bihar, writ petitions were filed before the Supreme Court regarding the practice of re-promulgation of ordinances by the governor. See, so it was alleged in the petition that the Bihar government is subverting the normal constitutional provision. See, as we know, in India we have the constitution has the theory of separation of powers. That means the state has different organs, for example the legislature, executive and judiciary, and all of them are given predefined roles. They are assigned predefined roles. For example, it is the job of the legislature to make laws, it is the job of the executive to implement laws, and it is the job of the judiciary to interpret laws as well as to adjudicate as per law. Now, Doctrine of separation of powers strictly says that one organ will not encroach upon the domain of another organ. That means the legislature will not perform executive functions, the executive will not perform legislative functions, as well as the executive will not perform judicial functions. So the different domains or sphere of authority of all organs have been delineated. That means if one authority encroach over the authority or domain of another, that would be deemed as unconstitutional. The fact was, the governor of Bihar promulgated 256 ordinances within a time span of approximately 14 years. Within 14 years, they promulgated 256 ordinances. That means in a year, they used to promulgate approximately 14 to 15 ordinances. And certain ordinances, they were kept alive for a period of 1 to 14 years. That means ordinance was promulgated, it lapsed, again it was promulgated, again it lapsed, again it was promulgated, again it lapsed. So this practice was continuing, and certain ordinances were promulgated or they were kept in force for a period of approximately 14 years. Now this is a blatant violation of constitution. See, out of 256 ordinances, 69 were re-promulgated several times. Now, what was the modus operandi? The modus operandi that was adopted by the government of Bihar was, as soon as the session of the legislature, state legislature is over, the governor of Bihar, or we can say the chief secretary of Bihar, he used to send a circular to secretaries of different departments and used to ask them to connect with the law department of the state to promulgate the ordinances again and again. So generally there is a procedure. The procedure says, if an ordinance has been promulgated by the state governor, so this ordinance will remain in force, and when the assembly, state legislature sits in session, so within 6 weeks of assembly of state legislature, this ordinance has to be passed. If this ordinance is disapproved, or if it is not passed within a time span of 6 weeks, the ordinance lapses. Now the thing here is, the Bihar governor used to promulgate an ordinance. There was no effort to pass the ordinance through state legislature. So obviously, when 6 weeks elapsed since the sitting of state legislature, the ordinance lapsed. Then a circular was issued to all the departments in Bihar government to re-promulgate the ordinance with the help of law department. So this was the modus operandi that was adopted by the Bihar government. Now I would like to enlighten you regarding ordinance making power. I told you ordinance making power is an emergency power that has been given to the executive to obviously deal with exceptional situations. Now if we want to read the relevant article, the article would be article 213 clause 1, sub article 1. Now this clause says, when the legislative assembly of the state, or where there is a legislative council, when both the houses of legislature are not in session, that means the state legislature is not in session. If the state legislature consists of only one house, if that house is not in session, if it consists of two houses, both the houses are not in session, and there is an emergent situation. So suppose now the government situation arises, the government want to pass a law, but as the legislature is not in session, law cannot be passed, and the government cannot wait till the time legislature again sits in session. So to deal with that particular period, to deal with that interregnum, the governor has the power to promulgate an ordinance, and that ordinance would have the same force and effect as the act of legislature of the state. Now, as soon as the state legislature sits in session, the ordinance has to be passed within 6 weeks from the day the legislature has sit in session, or it has basically gathered for the purpose of doing the legislative functions. Now let me tell you, article 174 of the constitution specifically states that the gap between two sessions of state legislatures, it could not be more than 6 months. So within 6 months the legislature has to reassemble. So suppose an ordinance was promulgated when the legislature has prorogued. Now the next session was after 6 months, and after this date when the legislature reassembled, 6 weeks from there, the ordinance has to be re-promulgated. So the maximum time span for which the ordinance can remain in force is 6 months plus 6 weeks. That means 7.5 months. So maximum time period for which an ordinance can be kept in operation, it would be 7.5 months. See, an ordinance made by the governor must cease to operate at the expiration of 6 weeks from the reassembly of the legislature. It is obvious that maximum life an ordinance cannot exceed 7.5 months. But as we have seen in the earlier slide, the Bihar government has promulgated ordinance that were kept in force through the medium of re-promulgation for 1 to 14 years. Now this is blatant violation of constitution. Now see, as a writ petition was filed and the practice of Bihar government regarding re-promulgation of ordinance was challenged before the Supreme Court. Now the Supreme Court gave a fantastic piece of judgment. Supreme Court conducted in-depth analysis of the constitutional provisions, and Supreme Court stated, obviously, it stated that power to promulgate an ordinance is an extraordinary power. This power cannot be used to subserve the political ends. Now, let me remind you, if you get this question, any question regarding the power of president to promulgate ordinance or the power of the governor to promulgate ordinance in the state, beta, you can use this judgment, because this is a judgment that has clearly redefined the power of executive power of the government regarding promulgation of the ordinances. So whatever I am displaying here, these are excerpts from the judgment of the Supreme Court, and you can use these excerpts for the purpose of writing your answer if the question comes. So now the court said, in every democratic country, executive is not given the power to make laws, but in extraordinary situations, an extraordinary power has been bestowed to the executive so that they can tide over certain emergencies. But that does not mean that the government starts circumventing the normal legislative process. The normal legislative process is that law must be enacted by the legislature only. Only legislature has the power to enact laws. But if the government, by using this exceptional measure, start subverting or start bypassing the ordinary legislative process, and it itself assumes the power to make laws, that would be a fraud on the constitution. The court said the constitution maker expected that if the provisions of the ordinance are to be continued in force, this time should be sufficient for the legislature to pass the necessary act. But if within this time the legislature does not pass such an act, the ordinance must come to an end. So this is the crux of the judgment of the Supreme Court. The Supreme Court again stated that executive cannot take over the lawmaking functions. The lawmaking functions will always vest in the legislature, and executive cannot assume that. The court said it would be clearly like subverting the democratic process. The government cannot bypass the legislature and without enacting the provisions of ordinance into an act of legislature, re-promulgate the ordinance as soon as the legislature is prorogued. The court said that would be nothing but a exercise of colorable power. That means the court said the executive is not allowed to do it. If the executive is bypassing the normal legislative process, it is nothing but an exercise of colorable power. So the court said it is colorable exercise of power on the part of executive, and it is unconstitutional. So the court clearly defined the scope of Article 213 for the governor as well as Article 123 for the president, and clearly stated that this practice of re-promulgation of ordinances without even making an effort to get them passed through the parliament or state legislature would be totally unconstitutional. And remind me, from that time onwards, this practice of re-promulgation of ordinances, this practice has nearly come to an halt. Now the governments are wary that if they tend to this practice, obviously such practice would be termed as unconstitutional. So DC Wadhwa versus State of Bihar, it is one of the fundamental piece of judgments that have been given by the Supreme Court of this country, and these judgments have deepened the roots of democracy in India. So the constitutional and the democratic values in India, these judgments have played a deep role to nourish those traditions, because in any country, democracy takes time to nurture. So when India enacted the constitution, we were a nascent democracy. But over the period of time, the Supreme Court gave, or Supreme Court or High Courts, they gave some fantastic piece of judgments, and those judgments, they basically helped in strengthening and deepening the democratic traditions in India. This judgment ensures that abuse of power, arbitrary exercise of power shall not take place, and any exercise of such power would be struck down by the court of law. So I will end up the video here. So I must tell all of you, it is an important piece of judgment. So you can find this judgment either in your preliminary examination or mains examination. And if you want to give notes, if you want to take notes regarding this judgment, you can also comment. We can provide you the excerpts from the judgment made by the Supreme Court as regarding this video. So that's all for today. We'll wind up as of now. We'll meet you again and we'll discuss some important piece of judgments or any news related to law in India. Thank you.